Hi everyone. Can everyone hear me? Okay. I will try to project. Please raise your hands if you can't hear me. So I am delighted to introduce to everyone our distinguished speaker for today, Marc Steinberg, the Rupert and Lillian Radford Professor of Law at Southern Methodist University, Dedman School of Law. Professor Steinberg received his bachelor's degree at the University of Michigan and received his JD from UCLA and his LLM from Yale Law School. He clerked for Judge Stanley Barnes of the U.S. Court of Appeals for the Ninth Circuit and Judge Anthony Celebrezzi, sorry if I mispronounced your name, of the Sixth Circuit. He was legislative counsel to former U.S. Senator Robert Griffin and served as the advisor to former U.S. Supreme Court Justice Arthur Goldberg for the Federal Advisory Committee report on tender offers. At SMU Law School, Professor Steinberg teaches securities regulation, business enterprise, and securities litigation and enforcement. He is also the director of the Corporate Directors Institute and the director of the Corporate Counsel Externship Program and has served in various top-level administrative positions at SMU. Professor Steinberg has served as a member of the FINRA National Judicatory Council and prior to law teaching held positions at the Securities Exchange Commission. Professor Steinberg is extremely prolific. He has authored more than 150 law review articles and 40 books, putting the rest of us to shame, I might add. In his latest book, The Federalization of Corporate Governance, which the library does have a copy of, he argues that the federalization of corporate governance did not begin as commonly believed in 2002 with the passage of the Sarbanes-Oxley Act. Federalization commenced with the enactment of the Securities Exchange Act of 1934 when Congress began to regulate short swing trading by insiders. And ever since, the SEC has played a key role in federalizing different aspects of corporate governance, using its rulemaking power to impact how the corporation is run, sometimes responding to and even reversing the impact of key judicial decisions. With this incredibly well-researched and well-footnoted book, I might add, and I'm particularly grateful for the footnotes. A single chapter has over 600 footnotes. Professor Steinberg has given the corporate and securities law community a superb tool for understanding the complex relationship between state corporate law and federal law, and the key role that the SEC and the stock exchanges have played in advancing federalization. That work, he argues, is not yet finished. So without further ado, please join me in welcoming Professor Marc Steinberg.
I'm so delighted to be here. Thank you for being here. I graduated from this law school 43 years ago, believe it or not, when I was 12 years old. Still put me at 55, right? I mean, my goodness. This is my first time back. And I remember having a talk with Dean Warren, Bill Warren, who's dean of this fine law school for many years. And it was about 10, 15 years ago, and I said, Bill, you know, I've never been invited back to UCLA. And I've worked hard, I've done pretty good, I've just never been invited back. And he said, I know how you feel. I've never been invited back to Illinois, where he went to law school, and he never was asked back. And of course, he was a giant in his field. He was a professor at Stanford before he came to UCLA, and never asked back to his home school to present, which he was eager to do. So I very much thank Professors Park, Bainbridge, Kim, and the Lowell Milken Institute for Business Law and Policy for me being here. It really means a lot to me. I walked through those doors literally for the first time in about 40 years. That's a long time. That's longer than most people in this room have been alive for a long time. And yet, many things were the same. The entrance was the same. The men's room was in the same place. The classrooms were in the same place. So much was very, very familiar, including my locker in my third year at the law school. I actually figured out kind of where it was. And a pivotal moment in my life occurred at that locker, believe it or not. And that is John Branca, who was in my class, who I became good friends with at one point. Of course, is a premier entertainment lawyer. He and I co-authored an article 2 years after our graduation on legal advertising that was cited by the U.S. Supreme Court in Bates versus Arizona State Bar. But John was at his locker. I was friendly with John. John was the AIC of the UCLA Alaska Law Review, which we used to have. I can say we after all, because I'm a UCLA law grad, which Duke, I gather, has taken over. It's a shame because that was a great review. You could read a student comment and we said it by the Alaska Supreme Court. He was talking to a friend, and he said, I applied to Judge Barnes on the Ninth Circuit. I had an interview with him. I don't know if I wanted to or not. And I really wanted to clerk because I knew I wanted to go into teaching. And I knew a clerkship was huge. And these clerkships are hard to get today. In my view, they're harder then because there are about 1/3 to 1/4 as many judges as there are today. So I said, I'm going to get my application to Judge Barnes. So I sent him my application. He gave me an interview. I went in. It went fine. And I did something very unusual, and that is I was extremely nice to his administrative assistant. We called in those days the secretary. I stayed afterwards. I talked to her for about 15, 20 minutes, and left. And then John Branca got the offer for the clerkship. And then he said, well, I really don't want to practice law. I don't really want to do a federal clerkship. I'm going to go into practice. I really don't want to do this. This is what he said. So I understand how the story went is that Judge Barnes then said to his secretary, well, who do you think I should give the offer to? And she brought in only my applications that remember that fine young man who said he wanted to clerk for you. And he picked up the phone and offered me a nice service clerkship, which just changed my life for the better. I mean, from there I got a fellowship to Yale, a full ride to Yale. From then I was legislative counsel to U.S. Senator, and then to the Securities and Exchange Commission. So it's amazing. I was just standing in that locker literally 30 minutes ago and saying this was where I was at when I overheard that conversation that really played a pivotal moment in my life for the better. It's amazing. It's amazing that happened. And this was such a wonderful school to go to. I grew up in Detroit. I'm sorry I'm not talking about the law, but after all, I've had 43 years to wait to talk about this. And I grew up in Detroit, and the expectation was I went to the University of Michigan undergrad, and I applied to law school, and I applied to here, and Stanford, and Yale, and University of Michigan, and Vanderbilt, and so on. And I was where maybe many of you were at. My grades were very good. It was they were a 3.8. That's what I graduated with, a 3.8 from the University of Michigan, honors history. And when I took that LSAT, I could have gone anywhere from Harvard to Yale to any middle range school. And I didn't do great. I did pretty good. I got maybe in today's parlance, maybe a 163. And I didn't get into Michigan because Michigan is flooded with in-state residents from the University of Michigan, and I didn't get in. And that was the happiest moment, one of my happiest moments of my life, because that unlocked the key where my folks would say, well, okay, now where can you go out of state that basically we can help to do? And I got into UCLA. And I came here, and it was a very young law school. It was less than 25 years old at the time that I came here. It was very supportive of its students. It was not an intense place as law schools go. The student body was very friendly. And really, I was able to excel, where I really wonder if I went to Michigan, for example, if I got in. My feeling is I I would have graduated in the middle of the class, would have been practicing law in Detroit, and that would be very good in my opinion. So it's amazing how things have developed. Now, you've heard that, you've come in to hear me talk about my book. What happened was that I was on a walk. I like to walk. I figure I still play tennis. I like to walk. It's good exercise. And once in a while, I get an intelligent thought. And I was just walking, and I said, you know, this Sarbanes-Oxley-Dodd-Frank stuff, you know, all that's important. People are written articles about it. But really, all this did not start with the Sarbanes-Oxley Act. This federalization stuff has been going on for decades. And I said, you know, I'm going to get a book proposal together talking about the federalization of corporate governance. And like many of you, I think once you get a good idea, you want to kind of seize the moment so you don't forget it, especially when I forget what I had for breakfast 2 days ago. So I wanted to really seize the moment. I really basically got home, and I got on my computer, and I wrote out off the top of my head basically a subject matter outline. And I said, basically, I'm going to try to hit a home run here. I usually get singles and doubles, and sometimes I do less than that. And I'm going to try to get this book contract from Oxford University Press. And fortunately, they gave me the book contract, and then I was able to write the book. And it was really some book to write. And I might add that 600 footnote chapter. I had a wonderful research assistant helping me with that, needless to say, for those 600 footnotes. And what that chapter does is it goes through every single bill that was introduced in Congress starting from 1903. So from 1903 to 1914, believe it or not, there were 24 bills introduced in Congress to require either federal chartering, requiring federal incorporation, or federal minimum standards. And then in the next 8 to 10 years after that, there were seven additional bills. So literally, that chapter goes through over 30 bills. And these bills are not on the internet, and talks about their provisions, and has some key floor speeches and so on with respect to that. And these bills, of course, did not go anyplace, but they did have some hearings. And in fact, both Presidents Theodore Roosevelt and Taft were in favor of federal incorporation. President Taft said that he was in favor of federal incorporation to remedy, quote, the abuses which have arisen under state control. So that during that period, 24 bills were passed, and then from 1914 to 1930, 7 additional bills were passed, one of which would have required the Federal Trade Commission to approve executive officer compensation in publicly traded companies. Imagine that. And then for whatever reason, and I really don't know why, decades passed before another bill was introduced. And that bill was Senator Howard Metzenbaum's bill that was introduced in 1980. And he was a Democratic liberal senator from Ohio, and he called for federal minimum standards, focusing on the duty of care and loyalty, such as self-dealing transactions, corporate opportunities, obligating directors to act with a reasonable degree of care. Hearings were held on that bill. They've been published. They're a nice resource. And then I thought that we were done with these bills, and then Senator Elizabeth Warren surprised me, because as you may know, last month she introduced the Accountable Capitalism Act, which insofar as I'm aware, she has not gotten one co-sponsor. Even Senator Sanders has not co-sponsored this bill. But what does it do? It applies to companies that have, publicly traded companies that have over $1 billion annual revenues. That is approximately half of the New York Stock Exchange companies, maybe a little bit more. And this would require these companies to obtain a federal charter from the newly formed Office of United States Corporations at the Department of Commerce. So I gather Senator Warren doesn't trust the SEC to administer this. Under her bill, there would be a brand new office set up. That boards of directors would have the obligation by law to consider stakeholders. They would be obligated to consider not only shareholders, but also employees, customers, and communities in which the corporation does business. Moreover, at least 40% of the directors would have to be elected by employees of the company. When directors receive stock pursuant to this bill, they would have a holding period of 5 years. And then if the corporation engages in a buyback of its securities, when a corporation goes into the market on the stock exchange and buys its own securities, then those insiders will have a 3-year holding period. And no political expenditure can be made by the corporation unless there's approval by 75% of the directors and 75% of the shareholders. So a very expansive bill. It has not been, it has not had much action so far. It was just introduced last month. And then lastly, many of you in business enterprise and in securities reg will look at the Santa Fe Industries case, 1977 case from the Supreme Court. This is a seminal case from the standpoint that this was the last effort to have federal minimum standards. And instead of going the judicial route, the plaintiffs sought to take the judicial route. And this involves Section 10B. And the feeling was, and you even see it in some Supreme Court, some Court of Appeal decisions in the 60s and in the 50s, and in some SEC language, that Section 10B has become a federal corporation law. And the argument that occurred there was we had a cash-out merger. Santa Fe Industries owned 95% of Kirby Lumber. Santa Fe had a cash-out merger in which it cashed out the public shareholders of Kirby. And instead of offering somewhere near what the physical assets were appraised at by Santa Fe's own advisor at somewhere around $675 a share, Santa Fe offered the Kirby shareholders $150 a share, basically on the Delaware block method, considering market price, considering assets, considering historical earnings, and so on. Green brought suit. His argument was that just because you know you're getting ripped off, it doesn't mean that you're not being defrauded. So this was the seminal constructive fraud argument. Constructive fraud, even though one is aware that he or she is being ripped off, nonetheless it's fraudulent. Believe it or not, Green won in the U.S. Court of Appeals for the Second Circuit, the preeminent circuit court, at least at that time, in corporate and securities law matters. He won that case. He went up to the Supreme Court. The Supreme Court ruled 8-1. Justice Brennan was the lone dissenter, holding that in order to state an actionable claim under Section 10B, there must be deception or manipulation. In other words, there must be a disclosure deficiency. Breach of fiduciary duty standing alone does not state a Section 10B action. So that was a huge case with respect to clarifying that there were some key limitations to Section 10B. So what is the modern day relevance of these statutes? Are they merely of historical interest and not really of modern day relevance? I take the position they indeed are of modern day relevance. One early provision found its way into the Clayton Antitrust Act of 1914, and that is that the early bills in the first decade of the 20th century sought to exclude corporate insiders from serving as directors or officers at competing corporations. And with certain exceptions, the Clayton Antitrust Act effectuates that objective. A number of these early bills required the corporation submit an independent auditor certification as a condition of the corporation receiving a federal charter. Today, of course, audited financial statements are a foundation of the disclosure process. They're required in SEC filed reports such as the annual report in Form 10-K. We have independent audit committees mandated, and of course we have CEO and CFO certifications, which the Sarbanes-Oxley Act requires. And then a number of these bills, as I mentioned earlier, require officer or director compensation to be approved by a federal agency. We don't have that today, of course, but we do have extensive disclosure. We have Regulation SK, the 402 compensation, the 404 related party transactions. We have the prohibition of loans to officers and directors. We have the shareholder advisory say on payroll. For those who are taking business enterprise, when you reach derivative litigation, you'll see a number of related party transactions. You might say, well, how did the plaintiff's lawyers ever find out about this? Because after all, wouldn't it be against the self-interest of the insiders to announce to the world that they are engaged in self-dealing transactions? How these transactions become known is that they're required to be reported by SEC rule. For example, today, self-dealing transactions that involve over $120,000 in a year, those transactions or series of transactions must be disclosed in an SEC form. What's a case that I remember from years ago was against Playboy Industries. Mr. Hefner would take the corporate check, use the corporate check for his parties, go through parties in the Playboy Mansion, and his benefits that he received from that, of course he was CEO, far exceeded the amount, which was less than $100,000 at that time, in benefit to himself. And that was not disclosed in the proxy statement of Playboy Industries, which publicly held company. The SEC brought an enforcement action based upon non-disclosure of those benefits. Now, as Professor Kim pointed out, the first federalization of corporate governance that was legislated is perhaps surprising, is overlooked, and that's the short swing trading provision and the prohibition against short sales by insiders. Short sales are generally, for those that don't know, is that the person doesn't own the security now. They have good reason to think that there's going to be bad news coming out, so the price will plummet. Well, this was used in the go-go 20s quite a bit. In other words, the insiders knew that bad news was coming out. So they sold short, meaning that they sold the security at the price the stock was today, and then they would have a certain number of days, such as that time, I believe it was about 5 days, to go into the market and cover their purchase. And by that time, after the public announcement, the price would have gone down. So they sold today, let's suppose, and the price is $20. If the announcement is made later this afternoon and the price tomorrow is $16, they go out, they buy the stock at $16, they deliver and receive $20. So Congress prohibited short sales by insiders, and then also said that if officers, directors, and shareholders who own 10% or more of an equity security, if they buy or sell and buy within a 6-month period in a properly brought action, they must disgorge all of their profit that they've made on those trades, irrespective of fault, a strict liability provision. And then what about the shareholder proposal rule? For those who are taking BE and have taken it, you know that the conducting of shareholder meetings, items placed on the agenda, that's all a matter of state law. But there are certain exceptions. And a key exception is the SEC shareholder proposal rule, which was adopted, believe it or not, in 1942. We're talking about a rule that celebrated its 75th anniversary last year. This is an old rule, adopted a mere 8 years after the 34 Act. And what this rule does, of course, is that it permits eligible shareholders to be entitled, if they meet the eligibility requirements of ownership interest and the amount of time they've held the stock, to include their advisory proposals. Their advisory, the board does not have to follow them, on the subject company's proxy materials. So there's no cost to the shareholder who provides the shareholder proposal. And subject to certain exceptions, these shareholders advance their social, political, and economic causes. Professor Bainbridge has written about the shareholder proposal rule. Not a great fan of it, not at all, I understand. And it's interesting, though, that the rule has served as a facilitator. Whether it's an accepted facilitator or whether it should be continued is another story, of dialogue, shareholder activism, between management and institutional shareholders. By the way, Professor Bainbridge and I have known each other for at least 25 years. At least 25 years. Yeah, while I was being conservative here.
1986.
1986, over 30 years. So, and of course, you know, he's having a fabulous career, no doubt. I mean, clearly. Very impressive. So, how do I feel about the rule? Well, what do I say about the rule? I feel differently than you do about this, Steve. When I say what I say is the shareholder proposal rule thus should be recognized as a vintage asset, a rule that has symbolized for 75 years that vibrant federal corporate governance at times is an appropriate vehicle for ameliorating state law shortcomings. So we part company on that one, but that's all right. Okay, what about insider trading? Insider trading, think about fiduciary duty of loyalty. That should be all an aspect of state company law. That's the duty of loyalty all day long. A fiduciary who is acting for his or her own benefit, taking corporate information that is corporate, that is not publicly known, and trading for his or her own benefit. But except basically for face-to-face situations called the special facts doctrine, many states did not police insider trading, or said it was okay because there's no harm to the corporation. And when it was finally decided upon by the New York State Court, one court, really the ball had already begun rolling by the SEC. And what was the cause about this? Was Chairman William Carey, who was appointed by President Kennedy as chair of the SEC. He was a Columbia law professor, and he had a very different view of insider trading than compared to former chairs and so on. What he said was that he wanted the commission to rectify state law deficiencies with respect to open market insider trading. Open market refers to trading that occurs in stock exchanges, for example. He says that it is, quote, shocking for business executives to personally profit from their inside information about the corporations they manage. I mean, no minced words there. And he was just waiting for his case. Only 1 year later, there's a case that came before the commission, In re Katie Roberts, decided in 1961 by the SEC. And Chairman Carey wrote the opinion for the commission, and the commission was very clear about the importance of the case. As I recall, the first line of the opinion says, this is I quote, this is a case of first impression and one of signal importance in the administration of the Federal Securities Acts. Wow, looking through the crystal ball. There the commission adopted the access approach, basically saying that one has unequal access. For example, being a director and officer of a corporation, one cannot trade on that information before there's public revelation, public disclosure of that information. The concern, though, was that Katie Roberts is an SEC administrative decision. No federal court had blessed that type of interpretation. But then 7 years later was the seminal Texas Gulf Software decision. I mean, that was the case that we'd look at in business associations, because this was before the U.S. Supreme Court decisions. Of course, when I was in law school, that case was only a half dozen years old. And that case, the Second Circuit, knew exactly how important the case was. The court took the decision in bank directly from the district court decision. In other words, the Second Circuit didn't even go into a panel of three. It directly took that case in bank. And the court expansively interpreted the insider trading prohibition. You can't tell in that decision, if you just read the language, whether it's the parity of information rule or the access approach. The parity of information rule is no matter how one finds out about the information, if it's material or non-public, one cannot trade on that information. The access approach is that if one has unequal access as compared to the general public, one cannot trade or tip. The SMU Law Review is doing a 50th year anniversary symposium issue for Texas Gulf Software. Professor Bainbridge is running that issue. Makes a very interesting point that Texas Gulf Software was not based upon the precedent that the Second Circuit cited. Excellent article. Thank you for contributing. It'll be out, hopefully, the issue in about 30 days or so. And by the way, for any of you that want to leave this lovely city of Los Angeles, Dallas is a wonderful place to practice. More affordable cost of living. We have, I think, either second and third highest number of publicly held corporations that are in Dallas. For example, I'm the director of the SMU Extern program, where we are sending 90 students this semester as externs to privately and publicly held corporations in the Dallas Metroplex. And I might add, the International Lawyer is published out at SMU. I much prefer to call my school SMU rather than Southern Methodist University, because that may have different impressions in different people. We have a very diverse student population. I was asked earlier, well, we understand that the rich kids go to SMU Law School in Dallas. Well, it is a beautiful campus. It is like UCLA, in that it is one of the handful of good universities in this country that have beautiful campuses in nice cities. Very few of them in the United States. SMU is one of them, as UCLA. It's a wonderful practice there, very sophisticated, I've been there since 1989, and it's been wonderful, and I've been able to do everything locally, nationally, whatever, from Dallas. And we have the many national law firms: Gibson Dunn, Jones Day, Caden, Chicago firm, a couple other Chicago firms, just one after another. Kirkland and Ellis, by way of example, they're coming in one after another. Let me talk about one way that the SEC has impacted corporate governance where it doesn't like a Supreme Court decision. The Supreme Court, 12 years after Texas Gulf Software, very much narrowed the scope of insider trading. Basically, the Supreme Court borrowed from state law principles and said that in order to have a duty to disclose and thereby be liable under Section 10b, that person must owe a fiduciary duty or relationship of trust and confidence, perhaps to the party on the other side of the trade, or under the misappropriation theory, to the source of the information, borrowing from state law principles. The SEC was very unhappy with this decision. And what it did, I was at the commission at the time, it adapted Rule 14E3. And Rule 14E3 only applies in the tender offer context. And in that singular context, the commission has adopted the parity of information rule. That it's strange that one can go to prison or one can totally keep his or her profits lawfully in this country today, depending upon whether the transaction is structured as a merger or a tender offer. It makes little sense to me, but that's the state of our insider trading law. So let me talk about some other issues here. I know you, hopefully you're interested in this, but I understand there's a limit to listening to me. Remember, I teach as well for many, many years. I've been teaching since 1982. So began at George Washington and then the University of Maryland. I had a visitorship at the University of Pennsylvania and then at SMU for the last 30 years. In any event, Santa Fe, I just talked about Santa Fe. What did the SEC do after Santa Fe? It adapted Rule 13E3. And what the commission has tried to do is impact substantive conduct through the guise of disclosure. In Rule 13E3, the party who is undertaking the going private transaction must disclose whether it reasonably believes the going private transaction is fair or unfair, and the reasons why. So therefore, if the transaction is unfair and the one affecting the transaction says it's fair, there's an SEC enforcement action and a private action for materially misleading statements. That's rather interesting. And then what about self-dealing? The commission has tried to minimize fiduciary self-dealing through disclosure, through these item 404, through 402 with management compensation. Not always successful, of course, but this goes back to 1964. 13E3 was adopted in 1979. The franchise proceeding, which was the first enforcement proceeding where the insiders did not disclose their self-dealing, occurred in 1964. This occurred quite a ways ago. And then the commission has tried to go beyond disclosure and in fact to impact corporate governance directly. The all holders rule. Many of you in BA will look at the Unicel decision, where the Delaware Supreme Court said that a selective tender offer, which excludes the hostile bidder under the facts of that case, was a permissive defensive tactic under Delaware law. The SEC did not like that decision, and what did it do? It adopted a rule that says, it's the all voters rule, that says when a publicly held company makes a tender offer, either a third party tender offer or an issuer tender offer to its own shareholders, that offer must be open to all shareholders. So in other words, what the SEC actually did was it overruled the Delaware Supreme Court on this issue. And then the commission has gone way beyond disclosure with the use of undertakings. We've seen the appointment of independent directors, the retention of special legal counsel to investigate and report, the appointment of independent consultants, and the retention of independent monitors. And what's the most recent situation we saw this? Just last weekend with Elon Musk and Tesla, where he settled, the company settled, and what's the condition? That Tesla appoint 2 new independent directors. And also that Mr. Musk resign his position as chair of the board. This goes way beyond disclosure. This is really impacting corporate governance, needless to say. The SEC. And what about undertakings? How far do they go back? You can say, well, that just occurred recently. Well, my favorite case happens to be a case I worked on as an SEC enforcement attorney, dealing with Occidental Petroleum that is headquartered out here. And Occidental did not disclose its environmental losses. It's contingencies, actions that were being brought, and so on. And these were the allegations. Oxy settled, and what was required? That Occidental appoint an independent director who was satisfactory to the SEC. The commission had to say, okay, that person is okay with us. Who was tasked with preparing an environmental report that would assess the cost of coming into compliance with the environmental regulations, and then to estimate the damages and penalties that Occidental was going to incur during the next few years due to its alleged noncompliance. What was the most amazing thing about that case? And for those of you who are not into corporate securities laws, what is fascinating about securities laws to me is that based upon disclosure, securities laws far impacts much more than finances. The Occidental case illustrates that, because here we had a major publicly held company that was allegedly polluting our environment. And the SEC played a key role in causing the remediation of that situation. But what was most amazing about the case is that the CEO of Oxy was a gentleman by the name of Dr. Hammer. Dr. Hammer was the CEO who was in control of all time. Because when a director came on the board of Occidental, he had them sign an undated letter of resignation. So the director would come on board, Dr. Hammer would take a letter, I resign, and they would sign it. And then if Dr. Hammer was displeased with the director's performance, then Dr. Hammer would simply date the letter, and the director resigned. This was not disclosed. This was not disclosed to shareholders when they voted for these directors. And of course, this was a disclosure violation. Absolutely unbelievable. So I'll just talk for about 7 more minutes. I'll stop at 5 more minutes, okay? The use of director bars. Since 1974, the SEC has used director and officer bars to preclude miscreant fiduciaries from serving as a director or officer of any publicly held corporation. Just not Tesla, of any publicly held corporation. And note that Congress gave the SEC the legislative authority to do this in 1990. Before then, the SEC relied upon its ancillary jurisdiction. So therefore, when we look at the Sarbanes-Oxley and Dodd-Frank Acts, yes, these statutes focus on independent directors, the composition, roles, and functions of committees of the board, such as the audit and the compensation committees, the prohibition of loans to executive officers and directors, the advisory vote on officer pay, and of course codes of conduct. But nonetheless, what they represent is a continuation of this federalization saga. And then the role of the national securities exchanges. Can you believe that the New York Stock Exchange in 1977 at the persuasion of the SEC over 40 years ago, required as a listing standard that all companies must have an audit committee comprised entirely of independent directors. So the audit committee rule goes back, of course the composition of that committee was a bit different than it is today, but the thought of having an independent audit committee goes back over 40 years with the New York Stock Exchange rule. And my point there is that the stock exchanges have also played an instrumental role in the Federalization of Corporate Governance. And indeed, many of the provisions of the Sarbanes-Oxley Act and Dodd-Frank Act condition listing on the exchange with compliance with what is set forth in those acts, such as codes of ethics. In order for a company to be listed on the stock exchange, the National Stock Exchange, that company must have a code of ethics for its senior executive officers. So where has the SEC failed? I will end with this because this part really gets me going. I run an article on this with my research assistant. What I do is that if I get a good research assistant, that person worked really hard, hundreds of hours. We write an article together, and he or she gets co-author status. My name goes first. They get co-author, which really is an inducement. I mean, but we wrote this article about the control person provision. Under the Securities Exchange Act, Section 20A, the SEC has the authority, as well as private claimants, to bring an action against those persons who controls anyone who violates any provision of the 34 Act. So who are control persons, for example? Normally, chief executive officers, chief financial officers, perhaps the chief operating officer, perhaps depending upon the context, the chair of the audit committee, perhaps the chair of the board of directors, I would think so, the lead independent director, if you have the chair being the same as the CEO, the chair of the compensation committee, depending upon the circumstances. These are possible control persons. Private parties, the plaintiff's bar uses this provision with regularity in class actions. You don't see many class action complaints that do not allege a control person claim against these fiduciaries. Throughout the financial crisis, with a Democratic administration, with Mary Jo White as chair of the SEC, a former U.S. attorney from the Southern District of New York, the commission could have sued all of these CEOs, all these CFOs in the aftermath of the financial crisis 10 years ago. It is an affirmative defense, the control person provision. Once the corporation is shown to have a primary violation, then the control person in most of the circuits has the affirmative defense of showing that he or she exercised good faith and non-inducement. So the pleading burden is minimal. The commission did not use this provision once. Not once against any executive of any of the big players. It fined, as we know, Bank of America with its public shareholders $16 billion, which if we're shareholders of Bank of America, we're paying for this. But yet it did not bring a suit against one insider. Now, just last month, the SEC settled a case using the control person provision for the first time that I can remember against against ITT, it's called ITT Technological Services, and settled that case. I like to pretend it was because of my law review article. I did send it to the commissioners and so on. But it's the first time they used that provision. So it's interesting that the SEC has had these provisions and they have not used it. Another example, I'll end with this, is that the Sarbanes-Oxley Act required the commission to adopt standards of conduct for attorneys. These standards were very debated. The bar, of course, did not like them. The SEC adopted these standards in 2003. Can you imagine how many enforcement actions the commission has brought to date with respect to a violation of these standards? The answer is 0. Not one enforcement action for these standards that have been adopted 15 years ago. So it's interesting that in some aspects, the SEC has been very, very vigorous, very aggressive with respect to the Federalization of Corporate Governance. While in other aspects, such as the control person provision, because that really does federalize the duty of disclosure. That is a fiduciary duty as well under state law. You'll see that in cases like Malone versus Brincat in your BA class. That with respect to some of these other aspects, the commission has declined to take any action. With that, I'll finish, and I'm just so delighted to be here, and thank you for making this possible for me.
Questions?
Well, I'm not going to leave. So
Okay, well,
I'm here.
thank you so much, Professor Steinberg. I met you just an hour ago, but I feel like I've known you for more than a decade. Just reading your law review articles and especially your treatise on insider trading with my friend Professor Lowell is just a real great resource. And you know, this book, which I highly recommend to the students in the audience who are learning about the subject for the first time, I think is an excellent introduction to federal securities law and corporate governance. It exhibits many of the virtues of your work. It's very clearly written, accessible, highly researched, and thoroughly exhaustive. So I think it's a great research and resource, and we're very proud to have you as an alum of UCLA Law School. And my hope is, someday we'll have a few people in this room become professors, whether in corporate law or some other areas. And it's, Professor Steinberg started out just like you 40 years ago. There's no reason that you can't follow in his footsteps and go on to a great law school to teach someday. So I thought I would start things off with my own question, which is that under the status quo, Delaware makes a significant amount of corporate law, and I think that would change, at least for big public companies, if Professor Warren's proposal was implemented and we had a federal incorporation requirement for big companies. And I noticed in your book you don't quite take a position on incorporation, on federal incorporation. You talk about it a lot in the beginning of the book, but I found your proposals to be very measured and very reasonable. Maybe a federal insider trading statute, maybe a few tweaks with respect to sort of the role of lawyers and control persons, but at least in the book you don't make the case for federal incorporation. But I just wanted to hear your thoughts about whether you thought that might be a viable option that should be considered, and also, if not, what role do you see Delaware playing in continuing to make corporate law?
Well, what's interesting is, as many of you know, in California, California just enacted legislation requiring publicly held corporations to have a certain number of women directors. Many publicly held corporations already have so actually the impact of the law, I think, will be rather minimal, because nearly every good-sized publicly held corporation already meets these standards. I know this is talking about state rather than federal, and the question is this law going to be challenged? Because, of course, many of the corporations that have headquartered in this state are incorporated in Delaware. And then under the Internal Affairs Doctrine, of course, Delaware law would apply. So it's the California legislation, one of these pseudo-type laws that will be given effect, or will be declared to be basically impermissible under conflict of laws principles. And it'll be interesting to see what ruling we get from the California court if it comes, and of course what ruling we'll get from the Delaware court if it comes. I have a feeling that they will disagree with one another.
But Professors Bainbridge and Grunfest and a bunch of others thinks that it's not enforceable as applied to corporations not chartered in California. And I think there's only 72 of the 4,500, or 75 that are chartered in California, and only 72 of the 75 have headquarters here.
Well, it really takes it's going to take a political decision for any corporation to challenge that, needless to say, I think, to challenge that law. But to answer your question, I know I got away for a moment. I did not want to propose anything in the book that I thought was not feasible to occur. So that's why my recommendations were measured, because I thought that perhaps these things will not happen, but they're doable. And probably the most far-reaching recommendation I had, really reaching out, which I'm sure Chief Justice Vesey disagrees with, is that with respect to tender offers, and these tender offers can involve tens of billions of dollars. The law is that these defensive tactics or offensive tactics taken during a tender offer battle are all part of the fiduciary duties that these directors and officers owe. They therefore become under the General Affairs Doctrine and are a matter of state law. So the consequence is that we can have a $20 billion takeover attempt that impacts global and international policy. And we have a state with very good beaches. When I was in DC and Maryland, I would have Assurant beach houses in Rehoboth and Dewey Beach in Delaware. And with less than 1 million residents in that state, meaning Delaware, that determine not only national but international policy. And I disagree with that. I think when we're talking about these types of transactions involving publicly held companies, then Congress needs to take a position, whatever that position may be. In the book, I don't argue what position it ought to be, but this ought to be a matter of national decision-making and not left to the state of Delaware, which of course is deriving very substantial revenues from companies incorporated within its borders.
Professor Bainbridge?
Mark, we're delighted to have you here. I first met Professor Steinberg in 1986. I was a law clerk for a federal judge in Baltimore, Frank Kaufman of infamy, and you were giving a CLE program at the University of Maryland, where I believe you were teaching at the time,
I was in Maryland from 83 to 89.
on securities regulation, and I went over and saw you at the program and briefly introduced myself, and then in 1992.
By the way, the woman I was going out with at the time was at your wedding, by the way.
I know, yeah. She was a good friend of my wife. And then in 1992, you may not realize this, but you're in some part responsible for the fact that I'm here, because in 92, he organized a academic conference at Pepperdine. And I came out in February of that year after a horrible winter back in Champaign, Illinois, where I was then teaching, and sat with you for an afternoon around the pool at the hotel over in Malibu, and thought, I've always been kind of anti-LA, but this isn't too bad. But I want to echo what Professor Park said about the book. It is a really wonderful book. The historical analysis is a tremendous contribution, and I wish I had my copy for you to sign, because I think it's going to be an enormous contribution to the literature. But you didn't talk much about sort of the normative aspect of all of this. And I just want to tell you an anecdote that leads into the question, which is in 2003, the Hoover Institution up in Palo Alto had their annual 3-day conference for donors and alums and so on. And I was on a panel with David Gregory, who was then, I guess then still is at NBC News, and a couple of other people, all of whom were much more famous than I am. And I was the last speaker on that panel, and I gave my talk, and then we broke for lunch. And as you would expect, most of the folks are running around trying to, talk to David Gregory or some of the other famous folks. But these 4 guys come up and say, "Come have lunch with us." Okay, and I go and I'm talking to them, and it turns out that they were all CEOs of auto parts manufacturers, to whom GM, Ford, Chrysler, so on outsourced making various car parts. And they were being incredibly squeezed because they were all unionized, the UAW workforce. But the car manufacturers were really pushing on prices. So these guys are operating on incredibly thin margins. And my talk had been about Sarbanes-Oxley 404, and I've been all doom and gloom, and this is going to be terrible, especially through microcaps, and it's going to, the costs are going to be blah, blah, blah. And they came up to me and they said, "You undersold it. You don't realize, but, it seems like marginal cost, but our margins are so thin that this is going to take a huge chunk out of our profits." And they were then talking about going dark. And you know, the numbers are debated, but there doesn't seem to be much doubt that SOX and Dodd-Frank did encourage a certain number of companies to go dark. And do we risk having the pool of publicly held companies shrink? Do you think that the federalization has been a cause of the decline in the number of publicly held companies? Or do you think it's just, you know, correlation is not causation, and we've had these bills, but they're not causally linked to what's going on?
To some extent, yes. I think the auditor review of the management of the controls, the internal controls, I gather, is quite costly. That's tried to be dealt with eliminating that with smaller companies. I understand we still have the management assessment, but you don't have the auditor assessment. So that's been helpful, and of course the commission last month came out with further reductions with smaller publicly held companies. But it does have an impact. On the other hand, just presenting the other side for a moment, and that is federalization at times has in fact, at least critics would claim, adversely impacted investors. And what are two examples? The first example is Rule 506 of Regulation D, where the SEC, in adopting the accredited investor definition, basically said if an individual has a net worth of $1 million, today it's exclusive of principal residence, then that person is deemed to be financially sophisticated and basically has access to registration type information. And of course that is not consistent with Ralston Purina and the case law prior to the adoption of Regulation D. And then, of course, what happened in the 1986 legislation, the NISPIA legislation, Congress granted state oversight of 506 offerings. So now the federalization means that these individuals who have a net worth of $1 million, as a matter of federalization, they're going to have to bargain for this information. They're not going to be entitled to this information. The second example is the Private Securities Litigation Reform Act of 1995, where, of course, in that situation, we had the pleading standards, of course, enhanced. We had the safe harbor for forward-looking statements greatly expanded. We had these costs, at least in theory, that were going to be assessed against the plaintiff's bar, although they have not. And then what happened after that is more and more of the plaintiff's bar went to California to file their class actions. 3 years later, Congress passed the Securities Litigation Uniform Standards Act, SLUSA, which basically says, with this exception in the M&A context, mergers and acquisitions, that class actions involving nationally traded securities under the Exchange Act must be brought in federal court with only federal law applying. So imagine this: if you have an ordinary investor who cannot opt out of the class because his or her loss, let's suppose, is $20,000, that suit can only be brought under federal law, asserting only federal law. Federal court, federal district court, asserting only federal law. State securities law, state common law cannot be brought in these actions. And who has that benefited the most? The lawyers, the bankers. Because in the old days, these individuals would be brought in under aiding and abetting under Section 10B, which the Supreme Court in 1994 in the Central Bank of Denver decision said there is no aiding and abetting. So these collateral actors now would be brought in under the state securities laws for aiding and abetting, breach of fiduciary duty, for aiding and abetting securities fraud, perhaps for negligent misrepresentation, those type of claims, which cannot be brought in the class action context. So it's kind of interesting that the federalization approach at times, in a minority of situations, really has resulted adversely to ordinary investors, but which has enhanced capital formation.
So first of all, thank you for coming here and speaking to us.
Thank you.
I want to apologize because I haven't had the chance to read your book yet.
Imagine that. You and how many other tens of billions of people would have.
Yeah, but I will say that being here today did inspire me. I'm definitely going to be picking up a copy.
Well, thank you.
And because of that, I want to apologize if this question is somewhat answered in your book, but I want to hear...
But remember, I've taught since 1982, so I've heard everything.
then you've definitely heard a little bit about Mark Cuban, of course, and his dealings with the SEC. On the courthouse outside after his ruling for a verdict of not guilty, he said that the SEC governs by lawsuit, that if you were to give them a call, they wouldn't answer any of your questions. So any obscurity in the law is always determined by them suing. And I wanted to hear your thoughts on whether the increased federalization of corporate governance has aided this, and in what case could we amend this type of ruling of the law?
Well, I think that's a good question. And it really hits home with me since I was Mr. Cuban's expert witness. And what's remarkable about that case is that the SEC has adopted a new rule, it's not new anymore, called Rule 10b-5-2, which was adopted by the Commission after it received an unfavorable ruling in the Second Circuit in a case called Chessman, where as an aspect of that rule, the Commission says that an agreement that is entered into not to trade comes within a relationship of trust and confidence. So in other words, if you and I are negotiating a deal, and you don't know me and I don't know you, and you give me information, you're going to, of course, require a non-disclosure agreement, an NDA. And you're having me sign this agreement for the very purpose that you don't trust me. Yet, under the SEC's rule, the signing of that agreement establishes a relationship of trust and confidence, so that when the person goes out and trades, that person has breached that relationship of trust and confidence. So how does this enter into the Cuban case? The Cuban case, what involved there was that he was an investor, 6% shareholder in a company of all things called Mama.com, an internet search company based in Montreal, publicly traded in the United States and the NASDAQ. Mr. Cuban would give his opinions. As you can imagine, he's not a shy person. And they were listened to, but he was not in control. He was not a fiduciary, and the Commission did not allege that he was. What happened was the company was involved in a pipe transaction, a private investment in public equity. And what that is a private offering whereby when those investors purchase in the private offering, the company registers those securities so that those investors can then sell pursuant to a registration statement, meaning that they can freely sell without having any holding period that they've got to hold their stock. Mr. Cuban was on record hating pipes. He thought they were detrimental to shareholders. In order to get investors to invest in pipes, generally a discount to market price has to be given along with other sweeteners like warrants. Well, Mr. Cuban got a call from Mr. Guy Ferret from Montreal. Great name for a person from Montreal, right? Guy Ferret. And Mr. Ferret said, these are the allegations. Mr. Cuban denied this happened. Mark, I've got something to tell you. You have to keep it confidential. Go ahead. And then he told him about the pipe transaction, and Mr. Cuban flew off the handle and said something like, damn, I can't sell now. Now, knowing Mr. Cuban, he did not use the word damn, I can assure you. In any event, based upon that conversation, the SEC alleged a violation by Mr. Cuban. So the case went to the jury, and the jury found a lot of things which were kind of surprising. One is the information was not material and was not public. Now, just maybe to get you on the edge of your seat, I'm finishing up a book right now on the Marc Cuban case. Right? Yes, and what it does is it's for experiential learning for law school, but of course I hope it sells a whole lot better than just in law schools. And it takes all sorts of pleadings and motions and court testimony and depositions and tries to read them into a coherent sense, and I give my own analysis and so on. So it's going to be published by this publisher called 12 Tables Press, which is affiliated with Carolina Academic Press. This is their new series. So that's going to be out hopefully in the spring. But I was with the SEC as an enforcement attorney in 1978. Nothing is different today. In other words, imagine the question is do prosecutors use sound discretion? Very often, yes, and at times, no. I remember as an SEC enforcement attorney, 3 years out of this fine law school, one of the best law schools in the country, UCLA, that I would work, 4 or 6 months in a case. I'd work on this case. And before that case could be brought, my supervisors would have to look at it, and supervisors above them before it would go forward. And of course, I always believed in good faith there was a case. Because remember, I wasn't the most objective person. I was involved every day for 4 to 6 months, and I didn't look at things as objectively as one would from a distance. And I remember one such case where I investigated the case, not entirely myself, and it was decided there wasn't enough there to go forward. So gee, you just mean I worked 4 to 6 months and I've got nothing to show for it? So I mean, this is a tough thing. And what's always good news when you're representing a client? What's your name?
Stephen.
Okay, and your last name?
Kane.
Mr. Kane. Would it be great news, Mr. Kane, if you were representing a potential target in SEC enforcement investigation, to find out that the attorney who was investigating your client has left the commission and gone to private practice? Because that means unless it's a real juicy case, where your client is right in the thick of the middle of everything, that means a new attorney is going to have to come in, pick up, and really have the same vigor towards your client, trying to establish a case, as that new SEC attorney is going to. So I really think that this issue has been a problem at times for government prosecutors, whether it's the SEC, whether it's the CFTC, whether it's the EPA, whether it's the Justice Department, whether there's a department within the California state agencies, that there's overzealous prosecution. I don't think it's an area of federalization as much as it is simply dealing with human nature and individuals acting in good faith and trying to establish a case. Mr. Cuba takes the position that the SEC acted arbitrarily towards him and really singled him out. There's no question that the commission staffers did not like Mr. Cuba. No question at all. Do I believe that they brought a case, believing they did not have a foundation? I don't believe that for a moment. I really believe that it's a rare situation where the government does not bring the case in the situation where the government does not in good faith believe a violation occurred. I really believe the government does act in good faith. They may be wrong, and they may be terribly wrong, but nonetheless, that's a situation. And the weirdest thing about that Cuban case is that Cuban had his economic expert who testified that the information was not material and the information was in the public domain. This information about the pipe transaction. The SEC had its expert at trial when Dr. Siri, Cuban's expert, testified as to this. Dr. Siam, who was the SEC's expert, was in the courtroom. He was also deposed by Mr. Cuban's lawyers. For whatever reason, the SEC did not call Dr. Siam to testify to rebut Dr. Siri's testimony. So the jury was only left with one side, and that was Cuban's expert saying the information was not material and then it was in the public domain. That is the weirdest tactic that occurred during that trial, and of course we don't know why. Was it because Dr. Siam had a personal situation? Was it because he changed his mind? Was it because the SEC was convinced that Dr. Siam would make a terrible witness? And I'm not saying he would have. I don't know one way or the other. I've never seen him testify. Or was it that they felt that they had put enough holes in Dr. Siri's testimony that it was ineffective? I don't know. And then another question is, why did the commission bring the case in the Northern District of Texas? They could have brought the case in San Francisco, for example, because Mr. Cuban, after he talked to Guy Ferre, talked to the placement agent at Merriman, Curran, and Ford that was located in San Francisco, and had a 7-minute phone call with the placement agent in San Francisco who told him about the deal. So the commission could have easily sued in the Northern District of California. Could have also possibly sued in the Southern District of New York. Because after all, that's where NASDAQ's market site is, and that's where it's very possible that Cuban's trades, which were affected by UPS, they were routed through New York. So it's possible they could have brought the action in the Southern District of New York. So why did they bring the Northern District of Texas. People who are favorable to the SEC say the commission doesn't play loose. This is where things mostly happen, and that's where the commission usually brings the action. Critics of the SEC say this is where the commission thought it would embarrass Mr. Cuban the most, in his hometown, and it would induce him to make a settlement. So that's rather interesting. Now, what also is interesting is in the Wiley case. If you remember the Wiley case, they're the ones involved with the tax fraud and so on. The Wileys are based in Dallas. I mean, there is a lot of stuff going on in Dallas. It's not like you're going to a smaller pond going to Dallas. I mean, it may not be as big as here, but it's big. You're swimming in a good-sized lake. There is a lot of activity in Dallas. And so what I was talking about, like I said, I can't remember what I for breakfast 2 days ago. I was talking about
The SEC decision to.
The Wiley case?
Cuban
the Wiley case. The Wileys are located in Dallas. They sued the Wileys in the Southern District of New York. After they lost the Cuban case in the Northern District of Texas, they shied away from the Northern District of Texas. They brought the case in the Southern District of New York. So that's interesting. So they had some choices where to bring that suit. And I think they brought in the worst place possible to do, because Cuban is well liked in Dallas. Now, as attorneys tell me, he's well liked throughout the country. What do you all think? How many people view Marc Cuban favorably?
Favorably?
Favorably. How many people view him negatively? And how many people are eh? Okay.
I have to disclose, I was with Latham and Watkins when we represented Marc Cuban on all of these matters.
Right, okay, great.
And I see
Right.
that Marc Cuban now is an informal advisor to Elon Musk. He was involved in
All right.
suggesting to Elon Musk that he settle.
Yeah, Latham was involved, and of course, Proskauer, Rupert was involved there, and of course, LaBeouf, Steve Vest, and so on.
We might have time for one more question, Daniela.
Hi. Do you expect that the SEC's ability to control corporate governance will change with the emerging trend of outsourcing the function of a board to a contractor?
My personal opinion is that as we go through good times, this has been the history since 1990, if not before. As we go through good times, we have greater deregulation. We have the states taking on a more prominent role. And then once we have a financial scandals or a depressed market or other types of fiduciary bad behavior, then what do we have is enhanced federalization. It seems to go through periods of time, because after all, 2 years after the Dodd-Frank Act, we have the Jobs Act of 2012, which has the emerging growth companies and a number of other provisions which are quite capital formation oriented. And in some ways, depending upon how far you're advancing investor interests, some of these provisions are not in the best interest of investors. So it goes through these cycles. And I think this outsourcing deal, if it happens to an excessive degree, and if there's scandals and so on, then we're going to have some federal legislation on this.
Thank you so much.
Thank you very much. Really good.
Yes, really wonderful.